Hey, Wesley, can you hear me okay?
I can.
Okay, I was just doing a check there. Now I got to make sure that I'm actually in the picture. It looks like I'm looking at an empty room.
You are not in the picture, but I can hear you loud and clear.
Maybe that's best. I'll just stay in the background here.
Okay, can everybody hear me?
Yes, sir.
All right, we're going to go on record here in Franklin Circuit Court for some previously scheduled arguments in the case of Beshear versus Osborne. It's number 21 CI 89. And before the court today, we've got motions to dismiss by the various defendants. So before we get into the arguments of the merits of those motions, let me ask, are there, if there are any preliminary matters that we need to discuss before we plunge into the arguments?
I
Okay.
don't believe there are any from the plaintiffs, Your Honor.
Yeah. Okay. All right. Well, hearing none, let's go ahead and hear the arguments. I think the Attorney General perhaps filed the first motion, so we'll let the Attorney General go first, and I'll recognize Mr. Maddox then.
Thank you, Your Honor. Good afternoon. I have here with me Carmine Icarino and Chad Meredith as well. So, Your Honor, we filed our motion to dismiss at the outset of this case because, as we pointed out at that time, there simply is no case or controversy for the court to address, wholly apart from the legislative defendants. The Attorney General has been sued on the proposition that he somehow is charged with enforcing or implementing SB1, SB2, and HB1. And of course, that is simply not the case. Effectively, the General Assembly passed legislation that placed some modest checks on the governor's exercise of executive power. And this was, frankly, at the invitation of the Kentucky Supreme Court when it decided the Beshear versus Acree case last summer involving the challenges to the exercise of emergency powers under Chapter 39A 100 and 180. And as the court said at that time, you know, the way to resolve the excessive use of executive power was with the legislative modification of those powers. And that's exactly what the General Assembly did. The governor apparently was unhappy with that decision, and so he filed a lawsuit almost immediately. And in naming the Attorney General, he mentioned the Attorney General effectively only in passing in his complaint. If Your Honor reviews the complaint, you'll find almost no substantive mention of the Attorney General and the actions that the Attorney General is charged with undertaking, required by law to do, or otherwise that have any effect on what Your Honor has called the implementation or the enforcement of the statutes. And I'll start with the easiest of the two, HB1 and SB2. There is simply nothing for the Attorney General to do in connection with those statutes. They became law when the governor's veto was overridden. The Attorney General has no role in directing a state agency and how to implement them, in affecting any regulations, in overseeing their operation in any way. There is nothing for the Attorney General to do to enforce them or to implement them. And I don't even believe the governor's papers, Your Honor, attempt to make a case that in connection with those two statutes, there is an actual case or controversy between his office and the office of the Attorney General. insofar as SB1 is concerned, there is the provision in that statute that whenever the governor chooses to suspend the operation of a statute, as KRS 39A 180 subpart 2 allowed him to do previously, he would now be required to have the approval of the Attorney General. So his lawsuit effectively seems to suggest that he has a legally justiciable interest in seeing to it that the operation of a statute that no longer is in effect, and effectively a statute that no longer exists, continues, and that he has, the same judicially recognizable interest in seeing that a new statute plainly permissible under Section 15 of the Kentucky Constitution somehow be enjoined. As we've pointed out, Your Honor, at the outset of this case and in our briefing subsequently, we have asked, how would this case be different if there were no defendants at all? And to this point, the governor's briefing and arguments, to Your Honor, have never addressed that question. Certainly, if the Attorney General were not present, there would be no difference in this case insofar as it involves SB2 and HB1. And insofar as SB1 is concerned, that, Your Honor, as far as we can tell, presents a purely hypothetical, subjective proposition. At this point, Governor Beshear has not declared that there is any statute that he intends to suspend, and but for the Attorney General's role under SB1, he is unable to suspend. Nor has he declared in any way that any action that the Attorney General has already taken has barred him from suspending some new statute. So at best, Your Honor, you have two statutes about which the Attorney General has nothing to do, and one statute about which there could be a hypothetical, purely subjective possibility that a case or controversy might arise in the future. But until the governor actually takes the action of announcing some statute he intends to suspend or has tried to suspend, there's simply nothing for this court to do. The reason, of course, Your Honor, that there is no case or controversy is because the governor has no standing in this case. Plainly, under the Sexton case, he has to demonstrate that there was injury, that injury was caused by the Attorney General, and that there is some redressability that this court might provide him that would resolve the case or controversy, at least insofar as the Declaratory Judgment Act is concerned. The lack of injury seems clear for the reasons I've already described. The lack of causation is equally clear, Your Honor. And as far as redressability goes, if Your Honor remembers, in the temporary restraining order, there was actually nothing done that addressed the Attorney General. Your Honor's order simply enjoined the implementation and enforcement of the statutes. In the temporary injunction that followed, the language of the temporary injunction purports to enjoin the Attorney General, but in fact, unless the governor can point out some action that is required of the Attorney General regarding implementation or enforcement, the injunction is frankly a nullity. It's as if there was an order issued in the abstract, which really amounts to, as we've suggested, an advisory opinion. I think Your Honor, we pointed out in our reply that while serving as Attorney General, Governor Beshear's office filed a notice in a federal district court case, pointing out that where there is no action for the Attorney General to take, an injunction against the Attorney General is effectively a nullity, and that's the case here. So for all three of those reasons, there is simply no standing on the part of the governor in this case. As far as the question of justiciability under the Declaratory Judgment Act, Your Honor, we've cited a variety of cases for the proposition that even within the Declaratory Judgment Act, there is still the requirements or the bedrock requirement of an actual controversy. We cited the Newkirk case. I don't believe the governor's office has ever responded to that. The court said, of course, this court does not have authority to settle arguments or differences of opinion. As we often say, we do not render purely advisory opinions. And of course, in that case, Your Honor, it's interesting because Andy Beshear was counsel of record in that case. And as counsel of record, he took an appeal to the Supreme Court or sought review of the Court of Appeals decision. And the Supreme Court in that case ruled against Attorney General Beshear and held that where the case had become moot, there was nothing for the court to do, and any judicial opinion would have been purely advisory because it would have no effect on any then existing controversy.
Yeah. Maddox, could you refresh my recollection about the Newkirk case?
Right, Your Honor. So that case involved a series of pretrial motions in which the Commonwealth sought to introduce evidence of a video, surveillance video, indicating that the defendant had, been at the scene of the crime, and it would have been used as evidence of his guilt. Unfortunately for the Commonwealth, that video had been taped over by the establishment that recorded it, and so the Commonwealth proposed to have a detective testify about the substance of the video that was no longer available.
Yeah.
The other element of it was that they had sought to have his brother testify against him, but they were unable to serve a subpoena. And so, given all these problems, the Commonwealth moved to dismiss without prejudice, a motion that the court granted, and in its order, it included a pretrial ruling to the effect that the video would not be admissible in any subsequent prosecution. And the court said, the Supreme Court said that that was no longer a live case or controversy, and so there was no jurisdiction for the Commonwealth to bring that case. Interestingly,
go ahead.
Yeah, on that very point, Your Honor, I think what's helpful is that the court said in that case that, quote, the Commonwealth argues that the issues are not moot because the Commonwealth may obtain a new indictment against the appellant. That possibility is only speculative at this point. So based on the record, there is only the potential of a new indictment, and the issue to be addressed has no immediate practical application outside the context of this case. So if the appellant were re-indicted, then the case could be teed up again and there would be a live case. Here, Your Honor, again, HB1 and SB1 really don't even raise the possibility of an actual case or controversy between the governor and the attorney general. But insofar as SB1 is concerned, the language that the court used in Newkirk about the speculative nature of the possible indictment is effectively the same as we have here. It's possible that Governor Beshear could choose to suspend some statute in the future. But, frankly, Your Honor, given the way the trend in the COVID cases is developing, dropping radically, the positivity rate below 3%, 9 confirmed deaths yesterday, a few hundred cases, vaccinations nearly 1 million. It seems highly unlikely that in the context of the current public health crisis, Governor Beshear would take the extraordinary action in the future of suspending additional statutes. Now, it's always possible that some other health crisis could develop, but that would be highly speculative. And insofar as the likelihood of him suspending some statute in this emergency, that might have been a different case a year ago or last summer, but this case seems just like the Newkirk case insofar as the legal principles are concerned. If some facts develop that suggest that there is an actual case or controversy, then Your Honor would have jurisdiction. But at this point, simply to say that there is the hypothetical possibility of a statute being suspended and the governor then not being allowed to proceed because the Attorney General withheld his approval seems to me to be far outside the parameters of what the Declaratory Judgment Act would allow.
Yeah. Well, let me ask you, Mr. Maddox, with regard to your all's position on Senate Bill 1, I guess it is, that the bill that requires some concurrence by the Attorney General on actions of the governor, is it your all's position, and I haven't looked at that here preparing for today, but it's your all's position that the only role for the Attorney General is on executive orders that would suspend statutes, that it doesn't apply more broadly than that to other kinds of executive orders or administrative regulations?
Your Honor, that is our opinion. I believe I would reserve the right to modify that position after further study, but that's certainly my impression as I sit here today.
Okay. All right. And again, I guess, as I understand the governor's argument, and we'll let Ms. Cubbage speak for herself on that, but I guess to my understanding to some extent is that the case or controversy is, as they argue it anyway, is that these statutes codify restrictions on the governor's executive authority and expansions of the authority of the legislature in a way that violates the separation of powers, and that to the extent that the Attorney General, as the chief lawyer for the Commonwealth, is arguing in favor of the constitutionality of those provisions, that itself creates a case or controversy. Now, I guess at this point, the Attorney General hasn't gone on record necessarily, certainly not in this case because you haven't filed an answer, as to the constitutionality of these statutes. But I guess it seems to me that the Attorney General does have, I think, to some degree, a statutory and a constitutional duty to defend the constitutionality of statutes. And I guess I'd like to know what the Attorney General's position is on these statutes as to the constitutional defects that have been alleged by the governor.
Well, Your Honor, you're correct, but of course, we haven't taken a position on the record on the statutes. I think that our first duty is to defend the Constitution itself. And we know that from the Sexton case that standing and justiciability are fundamental propositions that animate every case brought to the court. And so that's why we've pursued the motion to dismiss. Insofar as Your Honor,
Your position on that is that basically those are, you're arguing, what your argument is that those are threshold questions. So,
correct, Your Honor, correct.
So that until we cross that threshold,
Right.
it's not something that you all can be required to or should weigh in on, because I guess your position is that any dispute at this point is a theoretical dispute, not a concrete case or controversy.
Correct. I will say, Your Honor, that it's certainly our position that there is a strong presumption of constitutionality that applies to each of these statutes. And in the context of the briefing we've seen, I don't believe that presumption has been overcome by any means, but that's something that we would address on the merits down the line.
I understand that's really premature, I guess, in terms of the issues that are before the court.
Right.
So,
Your Honor,
okay.
I would just conclude by saying that to demonstrate the lack of redressability and the lack of standing, it's when Your Honor's injunction was issued, there is nothing that the Attorney General could do before that injunction that he couldn't do after the injunction within the context of these statutes. And there was nothing that he was required to do that he was not previously required to do. I'm just not sure, and it's not clear from the text of the temporary injunction what specific act or course of conduct Your Honor had in mind when it comes to the injunction applying to the Attorney General. So we would ask Your Honor to grant the motion and dismiss the case for lack of jurisdiction.
Okay, appreciate those arguments. I think it will probably make a little more sense for us to take these in order because they all do present some different, obviously different legal and factual theories. So why don't we go ahead and hear the governor's response to the Attorney General's motion, and then we'll turn to the legislative defendants. And I think with regard to the legislative defendants, perhaps we can, kind of consider those arguments together. But let's first hear the governor's response to General Cameron's motion.
Thank you, Honor. Taylor Payne, Your Honor. I'm here representing the governor, and I'm here with Laura Tipton, who's planning to address the Attorney General's arguments. And Amy Cubbage, General Counsel, and Travis Mayo, Chief Deputy General Counsel, are here as well. Mark Ferris and other Deputy General Counsels here. And I believe Wes Duke and Dave Lovely are here for the Secretary. But Laura will be taking this argument, if that's okay, and then I will address the legislative defendants.
Okay, very good.
Thank you.
Good.
All right, Ms. Tipton.
Good afternoon, Your Honor. Thank you. Next, I want to start with, the Declaratory Judgment Act is a little bit different because it does allow advance determinations of the parties' rights to eliminate or minimize the risk of wrong action by any of the parties. And here, the governor and the secretary have filed suit. They don't have to violate the House Bill 1, Senate Bill 1, or Senate Bill 2 and wait to be sued before getting a ruling on their constitutionality. And we would argue that there's certainly a case or controversy here, actual case or controversy under the Declaratory Judgment Act against the Attorney General with respect to Senate Bill 1. Senate Bill 1 would allow the Attorney General to have the unilateral authority to essentially veto an act of the governor. I would disagree that it's highly speculative that the governor would need to suspend statutes going forward related to the COVID-19 pandemic. This is an ever-evolving emergency. It also impacts so many things, including, as we've seen, unemployment, other types of benefits, and there have been statute education. We've seen statutes suspended that relate to all of those matters as well, not just statutes that relate to sort of the need for public health measures to be taken. And I think that the Board of Education of Boone County case is really on point here. We don't have to wait for the Attorney General to disapprove an order of the governor before filing suit. The court can take up whether or not that provision is constitutional. And the Attorney General has argued that under Section 15, it's plainly constitutional to give him that authority. We disagree. So I think that is evidence that there is a case or controversy here in suspending the law or delegating the authority to suspend the law under Section 15. The legislature must comply with other provisions of the Constitution. We have to read provisions of the Constitution together. And we argue that it violates Constitution Section 69. On the issue of standing, I think we have demonstrated actual harm, the violation of the Constitution, and a significant possibility of future harm to the extent the Attorney General would disapprove an emergency order that's meant to in some way protect Kentucky citizens during an emergency. And that would be redressable by an injunction that said that enjoin the Attorney General from disapproving or interfering with the governor's emergency executive orders going forward. And the court could enter that injunction, as well as a declaration that the provision is unconstitutional.
Ms. Tipton, let me ask you, Section 15, I think, prohibits the suspension of statutes except on the authority of the General Assembly. And there's not a whole lot of instances where, that power has been defined or implemented even, I don't think. Is it your all's position that in the context of a public health emergency that that is exclusively an executive function of the governor, or is there any possible legitimate role for the Attorney General to play in that kind of an order that would suspend a statute?
Well, let me see if I understand what you're asking. I think that under that constitutional provision, the legislature could give authority to the governor to suspend the law. He could perhaps give authority for the Attorney General to suspend the law in certain circumstances. What we're arguing is that he can't the legislature can't give that authority to the governor and then make it subject to a separate constitutional officer's veto power.
Kind of a veto, right? Okay.
Yes, I think, and the name of the case escapes me, but we saw with the reorganization authority, it could be delegated to the governor, but the governor can't then reorganize a separate constitutional officer's office. That would be unconstitutional. Yeah.
Right.
And then, so we believe the Attorney General is a proper party here for these reasons. There is an actual case or controversy. In fact, I think in our first hearing in this case, counsel for the Attorney General expressed the belief that Senate Bill 1 was constitutional, that provision. So clearly there's a disagreement here. There's adversarial interests here that the court can decide these issues. We're not just asking for an advisory opinion. The substantive rights of the governor and the secretary are at stake. And I would note that in boom circuit action, which the court may be familiar with, Florence Speedway. They're attempting to amend the complaint and raising issues about Senate Bill 1, House Bill 1, and Senate Bill 2. The Attorney General is a party there and has expressed that he would defend those statutes there, the legislation there. So we would think that he would want to defend them as well here, and particularly under Senate Bill 1, since that directly impacts his authority.
What is your understanding of the authority granted to the Attorney General under Senate Bill 1, Ms. Tipton? Is it strictly on these questions of the suspension of statutes, or is it broader than that?
I think our complaint against the Attorney General really, he's a proper party under Senate Bill 1, Your Honor, and under that section giving him absolute veto power over the governor's emergency orders.
Yeah, but is that only on emergency orders that suspend statutes, or is it broader than that?
The way we would read it, he could only veto orders that involve the suspension of statute.
Yeah, okay.
And
all right, we're having a little audio delay here, I think. So I didn't mean to cut you off, Ms. Tipton. But
no, I'm happy to answer any other questions, but I think we've also got it in our brief, so I don't want to belabor the points that we've made in our briefs.
Okay. Mm-hmm. All right, very good. Okay, anything else, Mr. Payne, that you all were going to add on the Attorney General's motion?
No, not to the Attorney General's motion, Your Honor. I would just add, I think your suggestion to take it's fine for me to address the legislative and LRC defendants in one.
Yeah, we'll do that then. Why don't we go ahead and turn then to the legislative motions to dismiss? We have very related motions, I think, from the LRC and from
doesn't apply to regular motion.
And Speaker Osborne and Stivers. So I will defer to you all as to who do you all want to, on the legislative side, who do you all want to go first?
Your Honor, it's Eric Lycan on behalf of Speaker Osborne. I'll take the lead if the court's okay with that.
All right, Mr. Lycan.
Well, Your Honor, we'll be very simple and very brief. The legislature has been sued in this case in violation of the doctrine of legislative immunity and in violation of the Declaratory Judgment Act. The legislators are absolutely immune from suit and therefore should be dismissed. I could go on, but that's the gist of it, Your Honor. And as this court has ruled many times.
Yeah. Let me ask you, Mr. Lycan, it does, you are correct, and I think you cited in your reply brief many cases, and it has typically been the court's view here that it's not appropriate to name legislators or legislative leaders in litigation challenging the constitutionality of statutes in general. Most, if not all of those cases are cases that have dealt with disputes between private citizens or other parties about an act that the legislature has enacted. Here we've got the unusual situation, I guess, of three pieces of legislation that the legislature has enacted that rather than expanding or restricting the powers of other parties in the executive branch or state and local government, it restricts these pieces of legislation restrict the power of the governor and expand the power of the legislature, raising some separation of powers concerns. And and looking at the case law dealing with those kinds of disputes, we do have, kind of I guess a different line of cases that deal with these kinds of constitutional disputes over the proper role of each branch. And we've got cases like LRC versus Brown, Rose versus Council for Better Education, both of which seem to indicate that in separation of powers types disputes, that the legislative branch is an appropriate party, and it's appropriate to sue the legislative branch through naming of the speaker and the president of the Senate. And so I guess, really, I would really like to hear you all what your response is to that line of cases and how you would distinguish this situation, this case from LRC versus Brown, Rose versus Council. I think Jones versus Board of Trustees of the Kentucky Retirement Systems is another case where legislative leaders were named as defendants, and all of those cases seem to indicate that in certain limited circumstances that deal with those kinds of separation of powers issues, that legislative leaders are appropriate defendants. So how do you distinguish those cases?
Well, first off, I would dispute that this is a separation of powers issue. This is not a case wherein the legislature is restricting the authority of the executive branch. It is the legislature modifying the delegation of its own authority, and it may delegate that authority as it so chooses in its discretion. When it has done so, that is an appropriate exercise of legislative power. So I don't believe this is a separation of powers case. I also don't believe the cases that you cited made it appropriate to sue the General Assembly based on separation of powers, but on certain specific constitutional duties that the General Assembly was not performing, that it has the absolute constitutional mandate to do, or is doing otherwise acting outside of the Constitution. Passing laws and enacting legislation is quintessentially within the Constitution and a legislative duty. Here, the legislature has passed those laws. They have enacted them and overridden vetoes. That's its duty. That's what it does, and that's what it has done. There is nothing left here for the legislature to do, nothing for the court to order the legislature to do or to not do.
Okay. All right. Anything else you wanted to add, Mr. Lykin, or do you want to pass the baton?
I'll go ahead and let somebody else inform the court.
Okay. And I don't know, I guess, Mr. Lykins, you all were briefing, I guess the speaker and the president were briefing the matter jointly, correct? So I don't see Mr. Fleener here, so.
Your Honor.
Okay.
Yes, we briefed that. I'm kind of far away. I'm far away from the camera. But no,
Okay.
Mr. Lykin and I are going to jointly brief because they're the clients.
Right.
Same thing. And the only thing I would add is I think the LRC v. Brown is a good example where the legislature was trying to actively do something in that instance, find regulations inadequate and stopping them from being enforced. I'm still somewhat confused as to what we're enjoined from doing. I mean, we passed Senate Bill 1, Senate Bill 2, House Bill 1. They were vetoed. The veto was overridden. We delivered them to the Secretary of State, and we're kind of done at this point. We're not actively enforcing or not enforcing. We have no role in it further.
Mm-hmm. Okay. All right.
Your Honor, could I
Yeah,
just have a short reply to Ms. Tipton?
Yeah, and I was going to go back and kind of let
Okay.
everybody do that together, but if you want to do it now,
No.
okay. Let's move on to Mr. Woolsey and
Yes.
then before we wrap up, we'll let everybody get a chance to have replies here today. So, okay,
Thank you,
Mr.
Your Honor.
On behalf of LRC.
Yes, Your Honor. So the arguments for LRC are similar to the arguments for the president and the speaker. And I would simply add that this court has previously held that a plaintiff can't name LRC employees or General Assembly employees as surrogates, essentially to get at legislators. You held that in the Seabolt case. You also held that in the Devine case. And that is consistent with opinions from around the country, most notably from the United States Supreme Court in the Gravel case, in which they said a legislator and his aide are to be treated as one. And so it's important to first note that the plaintiffs have not alleged any action by the LRC or any future action by the LRC. In fact, they've not alleged that the relationship between the governor and the secretary and LRC have materially changed at all from any of the bills. Specifically as the House Bill 1, it doesn't mention LRC at all. It doesn't include any language that would relate to the administrative regulations process. And it's quite frankly not implicated as to the LRC in the least. Senate Bill 1 and Senate Bill 2 touch on the administrative regulations process, but again, there is no change whatsoever between the plaintiffs and the LRC in those bills. And in fact, if you look at the response, the plaintiffs essentially acknowledge this. They state that they've named the LRC as the administrative agency of the General Assembly for its role in servicing the passage of bills, clearly impermissible, clearly immune, and can't be named as surrogates for the legislators, and for, quote, effectuating the intent of the bills. I'm not sure exactly what that means, but I think they're alluding to some action later taken in the administrative regulations review process. But again, there's nothing in any of the bills that change the relationship between the parties. They have made much of the fact that the word non-binding was stricken from the statutes. I think your Honor made reference to that as well. However, the fundamental process of how regs are reviewed, how a committee finds a deficiency, and how the governor can ultimately override that deficiency have not changed at all from these bills. Your Honor,
the bills really just, I guess, expand the existing framework for review of administrative regulations to include emergency regs and things of that nature, correct?
I might take a little issue with expand. I believe that the framework is largely the same. If the governor doesn't like a finding of deficiency by the Administrative Regulations Review Subcommittee or a subject matter committee, the governor can simply override that determination and keep the emergency regulation in effect.
Mm-hmm. Right. But there are some, I guess, some additional requirements for emergency regs in this one of these bills. I thought there were anyway, in terms of public hearings and so forth.
But all of those hearings, Your Honor, are the agency's responsibility. They have nothing to do with the LRC. They are not LRC hearings. At best, there's the possibility for a subject matter jurisdiction committee to hear a reg after the Administrative Regulations Review Subcommittee does. But again, they have no authority to overrule or veto a regulation. They can find it deficient, and then the governor can state that it's going to be implemented regardless of that finding of deficiency. The only other issue that they've taken note of is the expiration of regs, but the LRC does not state when a reg is in fact expired. That is essentially a judicial function, Your Honor. And so if the parties that are being regulated and the entity that is attempting to regulate them have a dispute about whether a regulation is effective or not, that's a dispute between those parties, and the LRC has no role in that process. That is a judicial determination.
Okay. All right. Anything else on behalf of LRC?
The only thing I'll note, Your Honor, is aside from legislative immunity, the Declaratory Judgment Act specifically states that an organization within the legislative branch cannot be named. It's a clear assertion.
Yeah, in a deck action, right.
That's correct, Your Honor. We've not waived we've not consented to this suit. We've not waived the immunity, and we're not a proper party.
Okay. All right. So, Mr. Payne, are you going to address the legislative issues here on?
Yes, Your Honor, if that's okay with you.
Yeah.
Well, thank you, Your Honor. And I think you adequately characterized this case in your questions to Mr. Lycan, in that it's an unusual case and it's unique. And that puts it in line with the cases of Rose, Philpott, Jones, and Kentucky retirement systems, where the dispute there was about the inner workings of government. And that's also what makes it very similar to LRC v. Brown, in that it's an attempt by the legislature to give themselves more power. It's an attempt by the legislature to execute executive actions in response to this emergency and future emergencies. And for those reasons, the legislators and the LRC are the only proper necessary parties to defend those portions of the bills that do that, Your Honor. In particular here, the legislative defendants have taken issue with our characterization of the separation of powers issues in our complaint, and LRC's taken issues with our description of the administrative regulation framework that we believe has been expanded and given LRC more power through SB1 and SB2. And I would just say to those arguments, Your Honor, this is the motion to dismiss stage. So the allegations, the factual allegations and the legal claims we've made in there are taken in favor of the governor at this point to
non-jurisdiction.
Right. Go ahead, Mr. Payne.
Sorry, thanks. But as to legislative immunity that the defendants claim, Your Honor, it is limited. It's limited in several ways, certainly by the express language of Section 43, which states that it only applies to members of either house from being questioned in any other place for the speech or debate on those floors. Section 43 then does not extend to the LRC. And legislative immunity, like any other governmental immunity, Your Honor, is subject to declaratory judgment acts challenging the constitutionality of government action. And here, where the legislature is attempting to act in an executive function, they're the proper parties to defend that constitutionality. The Supreme Court has touched on that most recently in the 2013 Kentucky retirement systems case, which affirmed Rose and Jones in addressing why the declaratory judgment, why sovereign immunity and any other governmental immunity does not apply when it's another government actor seeking a declaration of rights as to the constitutionality about other government action. And that's the situation we have here.
I guess when you get right down to the heart of of the argument, it seems to me like you all are arguing that there is fundamentally a dispute about with regard to the COVID emergency and the executive orders and administrative regulations that have been promulgated to address that emergency. I guess the fundamental dispute that you all allege is that there's a dispute over, the line of demarcation between what is an executive act and what is a legislative act. The legislature's argument is that with regard to the policies that are being implemented, that those are all strictly legislative matters, and that the legislature, out of necessity, has delegated some of those to the governor. And it appears to me that the governor is arguing that there are some, to some degree, that those responses are strictly executive, and and that the legislature can't restrict or has limited ability to restrict a fundamentally executive power. And I guess in this case, that the legislature can't delegate a legislative policy, legislative power, and then when the governor exercises the authority he's been given in good faith, that the legislature can't take it back if they happen to disagree with it. Again, it's kind of operating as essentially a legislative veto of the governor's authority for executive orders and administrative regulations. But that seems to me to be the fundamental nature of the dispute. And I guess it is, is that what you all are arguing, or have I misconceived that? Or
No, not at all, Your Honor. I think that is certainly a core piece of our argument. We've raised other constitutional issues with each of the bills. Certainly, I mean, I think with respect to some of their vagueness and how they would actually be implemented, causing real harm, certainly during this COVID epidemic. But yeah, Your Honor, the principal points here we're arguing is not just that it's the legislature has come in after the fact and sought to put
let me ask you about the on the administrative reg review portion of the legislation. It looking at all this, it does kind of strike me, that one of the issues is, is the legislature essentially micromanaging a power of the executive branch to promulgate administrative regulations, and I continue to be struck by the minute details and requirements that are codified in the statute, that regulations have to be submitted on 8.5 by 11 paper in 10-point Roman bold, and the margins have to be 1 inch and things of that nature. To what extent are you all arguing that the legislature's requirements in that regard are unconstitutional, or are you?
We are, Your Honor. I think, and as you touched on earlier, our principal arguments are that this expanded role for the General Assembly and LRC in overseeing certainly the emergency administrative regulations that the governor or any one of the executive cabinets would promulgate to address an emergency are being subject to limitations and micromanaging by the legislative branch that impede the governor's ability to carry out his executive functions in any number of things. But I think in principally in context of addressing the COVID-19 ongoing emergency that continues to exist.
Okay. And what's your response to, I'm gonna mix these up a little bit, I guess, so maybe this is more appropriate for Ms. Tipton, and I'm gonna go back to Mr. Maddox here in a minute, but to the argument that these disputes are really not ripe, that we're now in a situation where the COVID crisis is, if not past, that it has coming down the home stretch, and the legislature, that these disputes may never come to fruition, if we continue to successfully vaccinate the general population and the the need for these emergency measures is going to abate. We hope within the next 2 or 3 months that maybe the whole dispute is something that will not really come to fruition. What's your all's position on the ripeness issue?
Our position is that it's already come to fruition, Your Honor. The moment that the legislature overrode the governor's veto and enacted these bills, subjecting the governor's executive role and powers, if they were to be delegated from the legislature, to this micromanaging by the legislature. And I think that's certainly prevalent with the portion of SB 1 that subjects him to the potential veto of the Attorney General. What the case law says is that the governor doesn't have to go through that process and then find out he dislikes it that way, or it's onerous, or it's creating a problem. And he certainly shouldn't have to do that during a public emergency as serious as COVID-19. The moment they infringe on his power, which we've alleged they've done here, simply by the enactment of these bills, that creates the justiciable controversy that's ripe for judicial review.
Yeah. Okay. All right. Let me go back to Mr. Maddox then and let him pick up on his reply to the arguments that were made by the governor on the Attorney General's motion to dismiss.
Thank you, Your Honor. I would just point out that in their response to our motion to dismiss, Governor Beshear's office said at page 8 that they do not claim and do not ask the court to declare that he has unilateral authority to suspend the law. So there isn't any question, I don't believe, that the governor recognizes that the legislature has the power to enact laws directing him on this topic. And of course, in the Acree decision from last summer, the court said at page 812, 813, that while the authority exercised by the governor in Chapter 39A is necessarily broad, it is not unlimited. And it said that the checks on that power are the same as those that were outlined in the Chief Justice of the Michigan Supreme Court's dissent, one of those being, quote, legislative amendment or revocation of the emergency powers granted the governor. And of course, the final ultimate check is the ballot box. But the Acree court, the Beshear versus Acree court, Your Honor, effectively invited the General Assembly to do exactly what it has done. Now, as far as the justiciability goes, getting back to Ms. Tipton's point, she said that the governor is entitled to an advanced determination. And that's simply because of the existence of the Declaratory Judgment Act. But that statute, I think, is clear, requires that there always be an actual case or controversy. It doesn't provide a substitute for the existence of an actual case. Now, the only authority they offer for their position, I believe, is the Bushy case, the Boone County Board of Education case. And in that case, circumstances were entirely different. There was a statute that required a site-based decision-making council of a school district to submit a plan for that school district. And the school board took the position that the school board had the authority to approve that plan before it went into effect. So the statute required the SBDM plan, and the school board declared that it had the right to approve or disapprove of that plan. So in that case, there was no possibility of avoiding the controversy that was brought to the court. The plan was announced, and the question was, did the board, the SBDM board, have the a power to implement it, or did the school board have the power to veto it? One of those situations had to be the case, and the court had to decide. There was no avoiding it. Here, Your Honor, we have a situation that, as I said earlier, is entirely hypothetical. Neither Ms. Tipton nor Mr. Payne have suggested that the governor has any current plans to suspend any statute, either in light of the existing state of affairs or some potential new development. And until that happens, this is a case that is much more like, Your Honor, the case we cited in Nordyke versus Nordyke, another case that, if I'm not mistaken, the governor's office has failed to address in their briefing or in their arguments. In the Nordyke case, there was a question about the modification of a child custody order that had been issued by a court in Kansas. And one of the parents wanted that order transferred effectively to the Warren Circuit Court, but wanted to know in advance what the court would do effectively. And the court said that, unless and until some demand is made, there is no justiciable case before the court. It's fundamental that the court can't decide cases that have not yet ripened into concrete disputes. And Your Honor suggested a moment ago that the case here is not ripe, and I think that's exactly correct. In the Nordyke case, the court said, questions that may never arise or are purely advisory or hypothetical do not establish a judicial controversy, because an unripe claim is not justiciable. The circuit court has no jurisdiction over it. And that case seems to be exactly where we are here, Your Honor. I'll point out,
Mr. Maddox, aren't there some, at least my recollection is that there are some statutes that have been suspended by virtue of Governor Beshear's actions, which under the provisions of House Bill 1, his suspensions of those statutes would be nullified absent some declaratory or injunctive relief from the court. And we already have that situation, don't we? Or have I missed something?
Well, that's true, Your Honor, but it's not a function of anything the Attorney General might or might do. If previously suspended statutes are to have their suspension lifted by the operation of SB 1, it won't be because of anything Daniel Cameron, in his capacity as Attorney General, does or fails to do. That's simply not a case or controversy as between the governor's office and this office. Now, if in light of some operation of SB 1, those statute suspensions are lifted and the governor determines that he needs to suspend another statute, then if he had made that determination, if he had taken that position publicly, if he had advised the court that there was some statute, through affidavit or otherwise, that he would suspend, but for, the provision that just on principle, he doesn't want to ask the Attorney General to approve or disapprove, then arguably there would be a case or controversy. I mean, it might well be that the Attorney General would approve it, and then the only theoretical harm would be to his notion of his own power. But that, Your Honor, is not the situation here. We have a situation where he's effectively asserting an interest in maintaining, in effect, a statute which the General Assembly has declared is no longer operative. And if Your Honor were to enjoin the implementation of SB 1, right, then arguably that the effect of that would be that 39A in its previous form remained in effect.
He's he's challenging essentially the House Bill 1 on its face, not as applied. And your argument is kind of that he can't really maintain a challenge to it on its face, or because there's no current controversy. If he attempted to invoke the power to suspend statutes under the new law and the Attorney General objected, then and only then would there be a controversy, I guess, is your argument.
Your Honor, that's correct. You referred a moment ago to House Bill 1, and I think you meant SB 1.
Yeah, Senate, yeah.
Right. So in that case, I agree with your characterization of it. And so, Your Honor, that's simply, I think what the Nordyke case says is simply not a ripe case. Now, on the topic of HB 1 and SB 2, I'll point out that this hearing is now the third hearing in which the governor's office has failed to suggest in any respect how there is a case or controversy between the office of the Attorney General and the governor's office insofar as those two statutes are concerned. And I think at some point, the doctrine of waiver has to apply, and they are stopped from asserting going forward that there is a case or controversy insofar as those statutes are concerned. And of course, we've pointed out, why there isn't any controversy with regard to SB 1. And Your Honor, I would just, close by mentioning the Philpott case, which Mr. Payne mentioned. That case involved a question about whether the Senate rules were constitutional or not, and the Senate session had expired, or the Senate had adjourned, and so the court was concerned that there was no case or controversy there, and it alluded to the capable of repetition yet evading review doctrine, and in the context of that case, it said, well, if this does happen in the future and it seems like it's the same state of affairs, then we'll use this record as sort of the foundation, the evidentiary foundation for determining that there was a case in that case. It's conceivable that a similar approach would apply here, but again, that raises the question of whether there is some future action that the governor wants to take or intends to take or thinks he might be entitled to take that he can't take now. And until that's been articulated, I think this case falls into the situation that was addressed in Philpott, where the court dismissed the action and sort of reserved the question for the future. And
it's again, my understanding of the governor's argument on that point, though, is that he seems to be taking the position that the executive orders and emergency regulations that he has enacted that will expire by operation of law if they don't receive legislative approval, that they're all necessary to continue for the time being. Although I think, obviously we would all anticipate that in the near future that those would be, relaxed or altered or changed as the demands of the COVID crisis are altered or changed. Again, under the legislation that's enacted, if an order expires, he appears to have been divested of the authority to enact new or different regulations to govern those issues.
yes.
Seems to be the nub of the.
Yeah, Your Honor, I think you have gotten to the nub of it, and I think that demonstrates, perhaps more succinctly than I've tried to today, why there is no case or controversy here. effectively, Governor Beshear is trying to use the playbook that he used when he was Attorney General. As the Attorney General, he had a right to go into court and challenge the constitutionality of statutes. And that's a common law right of the Office of the Attorney General that I think the Supreme Court has made clear. And Attorney General Beshear, then Attorney General Beshear, made good use of that power. Whether you agreed with him or not, he was
frequent use of that.
Yes, as Your Honor well knows. Now, however, Your Honor, he is the governor, and in the office of the governor, he doesn't have that constitutional power to simply file a lawsuit, and as the Rivas case said many years ago, put the Attorney General on the other side of the V and announce that there's a case or controversy. Instead, Your Honor, Governor Beshear is obliged under Section 81 of the Constitution to see to it that the laws are executed. Now, when SB 1 and the others go into effect, their effect is what the effect is. There are two ways, Your Honor, and I said this at the initial hearing, that Governor Beshear can challenge the statutes. One is if there was a business establishment that was violating his orders, and he then, through one of his agencies, for instance, CHFS, imposed some order, cease and desist order, shutdown order, whatever it might be, the owner of that establishment could then, challenge the constitutionality of the statute. On the other hand, if he was taking some action that was inconsistent with SB 2 or HB 1, a business owner could sue the governor, and he could raise as a defense the unconstitutionality. There are two cases right now in circuit courts in Kentucky in which that very situation, is the case. One in Boone Circuit, one in Scott Circuit, and the governor's office, I believe, is a party to both of those cases. I'll stand corrected by one of the lawyers from the governor's office if I'm wrong. But that's the way in which there's a case or controversy. And here, Your Honor, there is simply no case or controversy where the only thing that's happened is that the governor has decided as a policy matter, he disagrees with the legislature and has asked Your Honor to declare it unconstitutional. I'll leave Your Honor with the question I started with back on February 3rd or whatever the date was. I don't know how this case would be different if the Attorney General were not a defendant, or in fact, if there were no defendants at all. The governor would make the same arguments, and the injunction that Your Honor might issue would be against the statute themselves. And I think, as we all know, that's not the way the judicial power works. So thank you, Your Honor.
Okay. All right. I'll let the governor's office respond to that if they want to.
Thank you, Your Honor. Just briefly, I would point out on page 5 of our response brief, we do address the Nordyke case. In Nordyke, the court found that a motion regarding jurisdiction, which was like a declaratory judgment action, presented no actual controversy because jurisdiction is a question of law that can only be addressed within an action itself, whether initiated through a complaint or a motion requesting relief. And according to the court, an actual controversy contemplates a conflict over the substantive rights of the parties. Here we do have a conflict over the substantive rights of the parties and over plaintiffs' rights and the constitutionality of the legislation that has been passed, which certainly impair plaintiffs' rights. I would also point out that I believe the Boone and the Scott actions that the Attorney General's counsel is referring to are really attacks on this collateral attacks on this court's injunction order. That's what those are. I don't think they would have been brought absent this court's injunction order. And the governor and the secretary are allowed to get the court's determination of the constitutionality of this legislation before they act contrary to the legislation. That is what the retirement systems case says, and that we cite in our brief, as well as I think Jarvis says that as well. I'm happy to.
Okay. All right. Any
Your
other?
Honor, so I apologize. May I briefly respond to Mr. Maddox as well, just because there was a little crossover of addressing those
Yes,
issues?
certainly, Mr. Payne, if you want to.
Thank you. I just very briefly wanted to state that, I think we would agree with Mr. Maddox as to, the governor's former role as then Attorney General, and what the Attorney General's role now is to represent the Commonwealth if, either defending laws or challenging laws as unconstitutional. But again, what's unique about this case and why the governor particularly has standing to bring this case against the defendants is because they're direct attacks and usurpations of his authority that he's been acting under for over a year now, his authority that was approved of in Beshear v. Acre last November, and the authority of his office going forward. So he is, precisely the person to bring this lawsuit against these defendants.
What's your response to Mr. Maddox's argument, though, that in Beshear versus Acre, the Supreme Court basically indicated that if the legislature was unhappy with the way that the governor had exercised the authority he'd been given that their remedy was to change the law and to restrict his authority, and that's exactly what they did. So that that the legislation certainly is not a under his argument, it's not a it's just the legislature responding to that direction from the Supreme Court, and the legislature has the authority to restrict the grant of authority that it originally made.
Well, I would agree with most of that, Your Honor, except for the last point that Beshear v. Acre says that the legislature delegated this authority completely and can now change that delegation, because the Supreme Court did say that the powers the governor exercised over the course of the beginning of the COVID pandemic were largely executive.
Yeah, I guess the underlying question gets back to this issue of what is an executive authority and what is a legislative.
Right, and I don't think the governor's not disputing the right of the legislature to change laws or to enact new laws, obviously. But what the governor's position here is that they're not able to do that in a manner that violates the Constitution. And because we've alleged that here, and because we're at the motion to dismiss stage, we think those are issues down the road for summary judgment, and would certainly get us past the motion to dismiss stage of the proceeding as is.
All right. Well, all of this has been very helpful.
Your Honor.
Yeah.
Apologies. The legislative defendants would like an opportunity to reply.
Yeah, absolutely.
So this talk has been about how unique this case is, and I would submit that it's unique only in that it's because the governor has done that which it is not permissible to do, particularly as relates to the legislative defendants. There have been mentions of the Boone County and Scott County actions to declare Senate Bill 1, House Bill 1, House Bill 2, those actions constitutional or not, and they're proceeding just fine without the General Assembly. General Assembly didn't bring those actions. General Assembly is not a party to those actions. But in those cases, the constitutionality of those acts may well be decided. I would also say that continuing to talk about restricting the governor's authority is the wrong way to view this. Suspending laws and exercising emergency powers depend on an affirmative delegation of authority by the General Assembly. That delegation under which the governor has been operating, it's not about giving him power and taking it back. that delegation no longer exists in statute. It is gone. The only delegation that now exists is the delegation by Senate Bill 1. It's not a question of the constitutionality. It's the question of what the General Assembly has delegated to the executive. And the only delegation that exists in law is Senate Bill 1. There's also been quite a bit of talk about micromanaging this crisis. The legislature is not in any way micromanaging this crisis. It is not micromanaging to enact a law and a policy that allows people to engage in commerce, to worship as they choose, to gather and peaceably assemble. If macromanaging is a word, then I've just defined it. Those are overarching policies on how our citizens can go about their daily lives. I would also say, just because an act may be unconstitutional does not waive legislative immunity or give right to sue the legislature. Legislative bodies pass laws all the time that are later declared unconstitutional by a court. And those are done so without the presence of those legislative bodies in the litigation. This litigation is solely about the governor's attempt to substitute his policy preferences for those of the General Assembly. The General Assembly is the policy-making body.
Okay.
Thank
Anybody else wanted to add anything?
Your Honor, if I may, I'd like to add something in reply for the LRC.
Sure, Mr. Wolsey, go ahead.
So the plaintiffs have made this characterization of the cases relating to sovereign immunity, and that it somehow affects the court's determination under legislative immunity. The courts have actually been very clear that legislative immunity applies in declaratory judgment actions in the Wiggins case from the Court of Appeals. And in the retirement systems case, Your Honor, the court was very careful to point out that the prior cases, Rose and Jones, concerned sovereign immunity. They did not concern legislative immunity. So the only case that bears on that question is Wiggins. Further, as to the LRC specifically, the plaintiffs have said that Section 43's express language only applies to members and speech and debate. However, numerous cases, including from this court, have held that it's much broader than that. It applies not only to members, but to legislative employees, to the clerks, to aides for the members, and it applies to a wide variety of activities, including committee hearings, investigations, gathering information, all of the things that the LRC and its committees and its employees may be involved in when it comes to administrative regulations. And then the last thing I'll add, Your Honor, is I'll follow up on what Mr. Lycan had noted. There's been this broad, somewhat obtuse argument about some expanded role of the LRC in this case. But the plaintiffs have not and cannot point to one thing in any of the bills that expands the role of the LRC when it comes to administrative regulations. Not one thing, Your Honor. And you noted micromanaging or the formatting requirements. Those issues were not amended in any of these bills. And the plaintiffs
Yeah,
have
that's
not
been the law
attacked
for
them.
a long time. Right.
That's correct, Your Honor. And they've not raised that as an issue. They've raised a facial challenge on the constitutionality of these three bills, and the case law is clear. The legislative defendants are not proper parties, and they've not made an allegation like in Rose or like in some of the other cases that there was specific action that can only be redressed by naming a legislative defendant. They've not named anything here that relates to any action we've taken, let alone that we're the only defendants that claim can be brought against. As Mr. Maddox noted, as Mr. Lycan noted, there are other cases proceeding in other courts in which they can make these exact same constitutional arguments without our participation. We're immune. We're not a proper party.
Yeah. Okay. All right. Anything else that any of the parties wanted to add for the court's consideration? I guess I also would maybe, at the risk of opening a can of worms that I shouldn't open, I am curious about the status. I understand there is legislation that that is under consideration with regard to the extension of some or some of the executive orders and regulations. Do we have any indication of, I guess whatever is going to happen on that's going to be resolved by March the 30th. So I assume that that's
Yes,
not
Your
going.
Honor.
Yeah. Go ahead.
The General Assembly enacted House Joint Resolution 77, which extended a good number of the governor's executive orders for a period, and there were others that it did not. That has passed the General Assembly, and the governor's veto decision will be
Still pending,
made prior to sine die. Correct.
Yes.
Okay.
Your Honor, I would note that the contents of that resolution was not discussed with the governor's office, and it expressly did not include any of the public health related orders that were the basis of your prior injunction.
Yeah. Okay.
Your
Well,
Honor,
again,
I have to object to that characterization. There's a
I'll
letter sent to the
just-
Speaker and the Senate President.
I'll just take judicial notice. There's probably a dispute about how that what the status of the events that gave rise to that bill, how they transpired, and that's not really relevant to the court's determination. But obviously, if if the parties do reach a resolution of that, the court would be happy to see that, and if the parties don't, then the court will go ahead and issue its ruling, and we'll see where we are after the ruling on these initial motions to dismiss. But I guess we'll have a definitive word on what happens or doesn't happen by March the 30th, because that's the last date, I guess, for legislative action. Correct. So, okay. All right. Well, with that, I'm going to go ahead and we'll recess, and I'm going to take the motions to dismiss under submission. I'll try to get you all a ruling as quickly as I can, digest all of this material and the arguments that we've heard today, which have been very helpful to the court. So I'll, again, thank you all for the arguments and the briefing that was submitted, and I'll take the matter under submission, and the court will stand in recess.
Thank you.
Thank you.
Thank you, Judge.